what class do I classify my goods when I'm applying for trademark registrations? I'm selling electrical goods. I'm not sure in what class it would go under. I'm working on trademark registrations.
Yeah, so it would depend on which types of products that you're looking to do. Like, so for example, like light bulbs would be like class 11, hand tools would be class 9, like electrical sockets.
Electrical goods. I'm picturing
electrical goods. So like maybe like battery chargers, like that kind of stuff, or
yeah, right.
It's probably going to be class 9.
Class 9.
Class 9 has a lot of like electrical products, kind of miscellaneous electrical products would be in there. Like tradesman's tools would be a different class entirely, but for some of these hands tools, or or I guess just electrical goods in general, probably class 9. But you'd want to talk to the client about it, get some more particular, product descriptions, because the USPTO won't let you register electrical goods, right? You got to be much more specific than that.
So bottom line, sounds like you got to get at least a consultation in, if not having help you file it.
It's going to be very specific depending on the product. So without knowing more, like electrical goods, I hear electrical goods, I think like electrician products, but we have lots of those clients. That's why.
My mind went to like consumer goods. Would that be something totally different, right? Or
potentially, like, battery chargers and stuff like that's going to be class 9, but it really depends. I mean, I'd want to know more about the actual product before I said, it's class 9 for sure. But just taking a guess, random, like stab in the dark, I'd say class 9 probably.
If someone decides not to listen to your advice, how dare they, and file on their own under the wrong class, what are the ramifications there?
So, if you have a somewhat friendly examining attorney, they might give you the benefit of the doubt, and they might suggest to you the actual product class for the products.
Okay.
Now, like if you have, a whole list of different products that you're putting in your initial application, it might fall into multiple classes. So the examining attorney might get mad at you, and he or she might, give you like 6 different, applications basically. And then you'd have to either accept their recommendations or kind of go back to them and give them something else in terms of the goods descriptions. But you might be in multiple classes at that point. So it's probably best just to talk to an attorney and just get it filed right the first time.
2 people apply for the same patent. Simple question. I think it can be taken at least 2 different ways.
Yep.
The first way I read this was you got co-inventors of the same invention. Can you both apply for it? I think the easiest way I should say is to have you both listed as inventors and use the same attorney. And that way you're all sort of together. In a lot of cases, the best way to do that eventually will be to assign your rights to a company. If you're in business together, you're planning to move it to market, you can both individually assign it to an entity, and that way it's governed and controlled by a business. Maybe if the question is being asked, can 2 people independently invent the same thing and apply for the same invention? The answer is yes. And who gets the patent? The one that files first. So it's all about that all-important filing date. And that's why there is a bit of a race, a lot of urgency to get patent applications filed as soon as you're able to get it to the point where it's an invention. And that's one thing that I know Troy, myself, when I do consultations, I sit down and help inventors appreciate, have you gone from that idea conception phase to an invention? Does it have enough meat on the bone? Have you been able to explain the invention so much that you could tell someone in your industry that much detail so they could make it and build it and use it? That's now at the level where you can actually file. And we recommend doing so as soon as possible. We do actually put one little hurdle in between. We say we should do a search. So a really thorough patentability search, especially if it's something outside of your industry, something you haven't done day in, day out. After doing that search, we want to get you filed right away. Matt, any thoughts on this, or maybe different ways the question could be asked?
Yeah, I mean, I guess from a trademark standpoint, you can have co-owners of a trademark application at the USPTO. I'm dealing with that right now. We represent a company that has a co-owned trademark with another individual. Nobody knows how that happened, right? Because the original attorney's gone. The attorney, the other party has no clue, right? It's just complete hearsay at this point, based on, we own it for this and you own it for that, and just a mess. So I always try to steer clear of dual-owned trademark applications, because it's just inevitably going to be a problem. So
Right.
You can, but you shouldn't.
Are translation services available for manufacturing patents and proprietary designs? I'm sure they are, but I don't know what that means. Let's see. Translation services available for
Does that mean, like, for example, like if there's like a foreign patent, right? Somehow gets translated back into English for, I guess, novelty purposes?
Goodness. I think that's good. Okay,
Yeah,
so
how do the examiners, when they search for, prior art, do they look in foreign jurisdictions? How do they do that?
yeah, okay. Well, U.S. examiners are looking for prior art around the world. I don't know.
I don't know either.
I don't know, but they're supposed to look worldwide, right? When you submit a patent application to the U.S., they're not looking to see if it's new just in the U.S. They're looking to see if it's new in the whole world ever, right?
Right.
So they must have some ability to do prior art searches, have translations, and if you will, whether it's manual, probably more automated. That's really good. It's really good, right? Foreign language. How does an attorney that only speaks English, an examiner only speaks English, able to read to see if it's prior art? It's an amazing question, and one that I will take back and report on next week.
Yeah, that's really tough.
Okay. One other thing I was thinking of was, you've got applications and patents. Well, sorry, you have foreign patents that have rights in foreign countries. Let's just pick one. Let's say China, right? It's in Chinese characters, okay? And you want to see if you're infringing that, right? Well, if you're only doing business in the U.S., you only have to worry about infringing U.S. patents. So that Chinese company would have had to seek a patent here in the U.S. Obviously have that translated into English and get that patent through, whether it was through the PCT or directly through the national phase of the U.S. So you'd still be able to look for U.S. English written language for U.S. patent rights, so you can kind of stay away from infringement. In any case, it's a great question.